You may proceed, Mr. Trengrove.
May it please you, Chief Justice, members of the court. I will address, firstly, the New Africa test and its application to this case. Secondly, the taxation of the delegation of taxing powers, and thirdly, the delegation of plenary powers. My learned friend, Mr. Marcus, will address comparative law. He's told me he can do it in 7 minutes, so I'll take 23 and he'll do 7 with your leave. May I start with the New Africa cause of action? And my main focus is going to be to submit to you that this cause of action was not pleaded, and that to entertain it would be to be in breach of the respondent's right to a fair trial, because they haven't had an opportunity to present the evidence they would have done if the case had been properly pleaded. So I'm going to take you through the pleading of the grounds of review, just to demonstrate that New Africa was not pleaded. The original founding affidavit, Chief Justice, I'll give the case lines references. All of these papers are in the 011 folder. The first one is at 011-28. That is their grounds of review, and the founding affidavit, paragraph 18.9. They say section 7.4 is patently unconstitutional, and then they list the grounds upon which they contend that it is unconstitutional. The first is that the power to amend legislation is a plenary power that Parliament may not delegate. So it's an absolute bar on the delegation of plenary powers. Secondly, it affords the minister a power to impose an irreversible tax. So again, an absolute bar on the delegation of a taxing power. Those were the only two causes of action they raised. And it wasn't only in that paragraph of the founding affidavit. They returned to it at page 011-53 in paragraph 103 through to 105. They say again, section 7.4 is patently unconstitutional. First, can't delegate plenary powers. Second, you can't delegate a taxing power. Now, those were the only grounds of review raised in their founding papers. SARS answered, responded to those grounds of review in its answering affidavit at 011-700 in paragraph 16. And you'll see in paragraph 16, its various subparagraphs, it addressed only those two grounds of review which had been raised in the founding affidavit and nothing else. The minister dealt with it, with the grounds of review, in his answer at 011-301 from paragraph 52 through to paragraph 55. And again, the minister said there are these two causes of action, and he addressed those two causes of action. And then the minister said in paragraph 54, although the DA has not advanced this case, I nonetheless submit that even if section 7.4 were to be treated as conferring plenary legislative power, it would withstand constitutional scrutiny, and he referred to New Africa. The DA in reply came back to the issue at 011-434 under the heading Impermissible Delegation of the Taxing Power, paragraphs 74 through to 79. And what they said is the minister misunderstood our ground of review. The critical paragraph is 77. The minister mischaracterizes the DA's case. The DA's case is that unlike the power to amend the regulations to a statute, the plenary power to alter the provisions of the body of a statute itself, it has been held to be unconstitutional by the Constitutional Court. This will be addressed in a further legal argument. So, and then in the Part B reply, the DA returned to it again at 011-764 in paragraph 5. And they again reiterated that their causes of action, their grounds of review, were the two that I've mentioned. Nowhere in the papers did they raise the New Africa balancing test ground of review. And that, with respect, is fundamental because it means that my client and the minister have never had an opportunity to place before you the facts that would be relevant to the New Africa balancing test. There was lots of debate this morning about why not these provisions, why not those safeguards, why not these limitations, what are the processes and so on. You simply don't know because the parties before you have not been asked to address those issues at all. And it is obvious that you can't fail to raise the issue and then raise it after the papers have closed and contend, as the DA does, that I'm happy to argue this new point on the basis of the evidence already before the court, the uncontested evidence. That's not the point. The point is not that the evidence is contested or uncontested. The point is that the respondents have never had an opportunity to place all of that evidence before you to answer all of these important questions that you asked today. The High Court addressed the issue and held that the New Africa cause of action hadn't been pleaded, but then said the following. At paragraph 33, the DA's reliance on section 77 and the contextual approach, that's the New Africa approach, does not introduce a new factual case. It advances legal argument based on the facts already pleaded. And that is so, but that is with the greatest of respect to the court, not the point. The point is that the respondents have never been called upon to address all of these issues relevant to the New Africa balancing test. So you can't then apply the New Africa balancing test when the respondents have never been afforded an opportunity and called upon to address it. In the High Court, the ultimate ratio of the High Court was in paragraph 86 and 88 of its judgment. That is at 011-811. It said the cumulative effect of these features is that Parliament's control over the imposition of the altered rate operates only retrospectively and prospectively, that is by either confirming the measure or permitting it to lapse, but not contemporaneously at the point of imposition. In the specific context of that, whose operation is sanctions-based and practically irreversible, this structure assumes particular significance. And then in 88, they articulate the founding reason for their conclusion that says it rests in the absence of the present design of section 7.4 of sufficiently defined statutory limits or mechanisms of prompt legislative control to ensure that the balance between the executive agility and parliamentary supremacy is maintained. That is exactly the point. That is the issue that a number of members of the court this morning raised with my learned friend. Those issues are cardinal to the New Africa ground of review. But they were not raised, and you weren't to have the answers to those questions on the papers precisely because they were not raised. So we submit with respect that the New Africa ground of review has not been pleaded. You don't know, have not been given the information to which you would otherwise be entitled had it been properly raised. And to make do as the High Court did on the facts placed before the court for other purposes is with respect not to observe the requirement of audi alteram partem. The respondents have not been heard on this issue. So we submit with respect, and let me add this. You have seen from our heads of argument, Annexure A to our heads of argument, we've raised a very long list of comparable provisions. So, and we did that, that's the best we can do because at least that's law, not fact. But what it does is to show that this type of provision, which delegates the power to adjust rates and taxes, is a very commonly used, very long used, very frequently used mechanism. You deserve an explanation from the people in the know why that mechanism has been so important, has been so frequent, has been so pervasive all the time. If the question is what are the safeguards built into the system, you're entitled to those answers. If the question is why don't you have better safeguards, that is the question they need to address. If the question is, well, shouldn't there be a further limitation, those issues are important. They are not addressed because this ground of review was never pleaded. So we submit with the greatest of respect that the case cannot be decided on a ground of review that was never pleaded. Can I turn to the second ground of review, the delegation of a taxing power? Now remember, our learned friends, the DA's cause of action is that twofold. They say a taxing power cannot be delegated. And it's common cause. There's no debate. This court has often held that the power to impose a tax cannot be delegated. But it's a completely different question when you ask whether a component of a very large structure created by an act of parliament, whether the power to make adjustments to that component can be delegated or not. Now, again, we submit with respect that there is no absolute rule against the delegation of any component of an act by which revenue is raised. There is no suggestion that there is anywhere in the Constitution a bar of delegation in a revenue-raising act of parliament. The question whether such a delegation is permissible or not would be subject to the New Africa balancing test. In that test, one would ask yourself, does it satisfy the New Africa standard that this element of the VAT Act has been delegated to the minister? And then you apply the various criteria. The fact that it might be an amendment to a tax act may be an important fact. The fact that it may be a power to amend the tax rate may be an important fact. But there is no basis for the DA case which says that there is an absolute bar on the delegation of a power to set the tax rate. There is no reason why the legitimacy of that delegation shouldn't also be judged by the New Africa test. There's nothing in the Constitution to suggest that there is in this case, whereas delegation is otherwise permissible, subject to New Africa, in this case there is a specific bar on the delegation of a taxing power. The DA's case is, and has to be, as they say in paragraph 56 of their heads, that adjusting the rate of a tax is functionally the same power as imposing or abolishing the tax. But with the greatest of respect, it is not the same function. Look at the Tax Act. Look at the big structure of all of the rules Parliament has put in place in order to levy tax. I'm not suggesting that the tax rate isn't important. It is important. But it is Parliament that created the structure, who is taxed, how are they taxed, at what level are they taxed, and so on. And what it is delegated is this one component of theirs, and that is to change the tax rate. Again, I'm not underplaying the significance of that power, but the test is the New Africa test, that there is no absolute bar on the delegation of the subsidiary power to adjust the tax rate. May I deal briefly with the question of the effect of Section 77 of the Constitution on this question. With the greatest of respect, the structure of the Constitution is that it classifies bills before Parliament in 4 different categories. Section 73 applies to all bills. 74, bills amending the Constitution. 75, ordinary bills not affecting the provinces. 76, ordinary bills affecting the provinces. And then 77, money bills. So it is a broader structure in which the procedure, there are different procedures prescribed for different kinds of bills. And 77 is no different from the other categories. What it does in its 2 sections, by the way, it has no special procedures prescribed. What it does in subsection 7.1, it says a bill is a money bill if it does various things, if it raises taxes. But it starts off by saying a bill is a money bill. So it can't be a money bill if it's not a bill. It's a category of bill. It's a money bill if it does certain things. Subsection 2 tweaks that definition, which says a money bill may not deal with any other matter except. So it sets rules as to what may go into and what may not go into a money bill. But then subsection 3 says a money bill must be considered in accordance with the procedure established by section 75. That's the procedure for ordinary bills not affecting the provinces. So section 77 is not peculiar. It is a different category of procedure prescribed for Parliament. And there is nothing in the Constitution to suggest that when delegations are made in any of these pieces of legislation, that the procedure by which it is enacted in Parliament in any way affects the permissibility or the validity of the delegation. New Africa will determine whether it is a permissible delegation or not. But there is nothing in the Constitution to suggest that this one kind of bill may never delegate a significant power. The general rule applies, and that is New Africa. And again, we refer to our Annexure A. See how common a feature it is, and has always been, that Parliament delegates those powers to the Minister. May I turn lastly to the delegation of plenary powers. Our learned friends suggest that the foundation of their argument on this score is that the delegation of plenary powers is not permissible. They say that principle was established in executive council. But with the greatest of respect, firstly, executive council didn't establish such a principle, and if it did, the jurisprudence of this court has moved on since then. But if I may refer to executive council, in paragraph 62, the majority judgment of Judge President Shaskelson, where he firstly expresses himself against the proposition of the delegation of plenary powers, but then he says the following: it is possible that circumstances short of war or states of emergency will exist from which a necessary implication can arise that Parliament may authorize urgent action to be taken out of necessity. And then he mentions a national disaster and so on. So he didn't pronounce an absolute rule. He acknowledged that there may well be exceptions to the rule, and he didn't explore the boundary of those exceptions. So the Executive Council did not establish a general rule against delegation. And since then, there have been a number of other judgments, but it culminated in New Africa. We submit with respect that New Africa unambiguously held that there is no bar, no absolute bar, as the DA contends, on the delegation of plenary powers. They seek to make a distinction by drawing a line between plenary powers of taxation and plenary powers of delegation of other legislative powers. But with respect, the foundation on which they start, that Executive Council created an absolute rule, is a false foundation. And the law at the moment is the one announced in, or pronounced in New Africa, finally pronounced in New Africa, and that is that plenary powers may be delegated, there's no absolute bar against it, and it comes down to the application of the New Africa test. And that is the one thing they didn't plead. They didn't plead that if the New Africa test applies, that this legislation fails the test. Thank you, Chief Justice.